Mr. Vanden Heuvel on behalf of the plaintiff, Ms. Oster on behalf of the defendant. This is the defendant's motion for a temporary order. Ms. Oster.
Good afternoon. There's actually two motions. We both filed motions. I'm happy to
Oh,
start.
yes, there are. Yes.
If Mr. Vanden Heuvel wants to go first, since he filed his first, that's fine too.
That's fine, Ms. Oster. I'm great with that.
Okay.
Okay.
So Your Honor, I wanted to first, obviously there were two motions filed, responses filed to both motions. There's a lot of information here. I want to first just state for the court the agreement that the parties have is number one, that we need a temporary order, including Ms. Stewart being awarded exclusive use of the home. We need a parenting time schedule, and we need a financial order in place regarding payment of bills and or support. Where the parties differ is how that separation is going to occur, specifically with respect to parenting time and finances. They're pretty far apart in those issues, so I want to focus on those. Mr. Stewart maintains that the children's best interests are served by the parties being awarded joint legal custody. He sees no basis to award anything other than what we would call a 225 parenting time schedule or a week on, week off parenting time schedule. Ms. Stewart's motion essentially asks that she be awarded primary physical custody and that Mr. Stewart's parenting time be restricted to every other weekend, which is generally uncommon. We hardly even ever see that today, except in extreme circumstances. Her basis for that is almost completely relying on psychological terms, conclusory language, buzzwords, but no real facts to support those claims. And most certainly nothing related to the children's best interests. As a summary, both of these parties are active and involved parents. The children have always enjoyed consistent, meaningful involvement with both of their parents throughout their entire lives.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. All right, this case is already a pressure cooker. Mom wants primary custody and restricted dad time. Dad wants 50-50, and the judge is about to weigh labels versus hard proof. And wait till the money talk hits, because the numbers do not match the demands. Who's being real here?
Mr. Stewart is involved in the children's daily care, education, medical care, extracurricular activities. We believe, and the children are of appropriate age to provide their preference. We believe the children wish to spend equal time with both of their parents. They do not wish to be restricted to seeing their father every other weekend. Contrary to claims made by Ms. Stewart, Mr. Stewart is fully trained, actively involved in the care of their daughter, Laura, who was recently diagnosed with diabetes. He's cared for her since that diagnosis, and even cared for her independently while Ms. Stewart was away traveling. Also, contrary to their claims, Mr. Stewart has every intention and can make sure that all the children get to school where they need to be, regardless of whether the parties are living in one house or not. He has secured a residence very close to the marital home. All the children have a bedroom in that home, and he has access to assistance for transportation if needed. Their daughter, Laura, spent some time in Pine Rest. And my understanding is the diagnosis was related to anxiety, but less about the anxiety she has for her illness, more about the anxiety she has with the conflict with her mom. My understanding is that there has been police intervention. Ms. Stewart has initiated police intervention because of conflict with Laura as recently as of this past Thanksgiving. I see no reason for the court to order anything other than 225 schedule, get these kids on a regular schedule, spending equal time with their parents. They'll be responsible for their care when they're in each party's respective homes. I actually think that should be the relatively simple issue. The more complicated issue is the financial situation. Mr. Stewart is a high school teacher in Cedar Springs. He's a great teacher. He's well-liked. He's been a finalist for Teacher of the Year in Michigan. In addition to that, He owns and operates a consulting business. It is a business that he developed on his own based on his experience as a teacher. He writes books, he does speaking engagements, and he provides digital data or digital information and platforms for educators. He travels, he markets. When I say he travels, the business involves marketing, traveling, a number of expenses directly related to the business. So one area where Ms. Stewart is incorrect is that Mr. Stewart is using this business to fund his personal life. That's just completely inaccurate. The business has expenses, but they're almost all directly related to the travel, the marketing, the continuing education, online platforms, those types of things. In 2025, which is the most recent information we have, the business had gross revenue of approximately $180,000. We're not talking millions. And at least half of that was legitimate real business expenses, including $45,000 in taxes. And then on top of that, travel, marketing, those types of things that he needs to spend in order to have this business. The profit for 2025 was probably about $60,000. It has been higher in past years. The business does well when schools have funding to pay for these services that he provides. And as everyone is well aware, funding is being cut at all levels of government right now. And so the funding has not been there. His business was highly successful post-COVID, when there was a lot of online activity and additional funding for schools. So the trend has been a decline. But he is not trying to paint this picture that he's throwing away this business and not making any money. He does better. The family does better if this business were to do better. But the bottom line is that's what the 2025 profit was. As of today, Your Honor, in their finances, this is what their finances include. There's a business chase account that has about $6,000 in it. As reported by Ms. Stewart, Mr. Stewart transferred $6,000 from an Ally account into this Chase business account so that he could hold that money for their 2025 taxes. That money has not been spent. It's sitting there. If the court says he has to give her half of it, he'll give her half of it, but then she's going to have a higher tax liability when they file their taxes for 2025. So that money is sitting in that account. In another account, he has $6,600 in a checking account. All of that money has been money that he's been loaned by his family, including money to use to get his new apartment, his new home, because there's just not enough money to go around. The business checking account right now is negative. There's an overdraft in the business checking account. So the $6,200 is in his personal savings, $6,600 in his checking. That's money from his parents. The parties have an operating account that they use, a checking account. As of last night, when his teaching income was deposited, there's about $1,600 in there. Another point for clarification, he was not just paid $8,500 for a job. He was paid $8,500 in August for a job the speaking engagement that he just had, but he was already paid for that. That money is gone. So this business isn't regularly taking in money and he's not making money on a regular basis like a W-2 employee. So I've been trying to think of the best way possible to clean up the mess that's been made of these parties' finances at this point, because there is no money, there's no profit left from the business at all. There's no cash. So he earns a net monthly income from teaching of $38.50. He is in the process of increasing his hours, not decreasing his hours, because the parties are in a financial crunch. If we used a conservative number of $60,000, which was, again, the profit the business earned last year, that's about $5,000 a month in additional income. So we are working with...
Here's the legal tension. The court isn't just judging feelings, it's judging ability to pay. If the business profit is hypothetical, then demanding $7,800 per month can look unrealistic on paper. This is why judges ask for accountings and tax clarity, because gross revenue isn't take-home money. Be honest, if you were the judge, would you base support on hopeful income or only what's proven?
And this is, again, this is hypothetical income because that $5,000 a month may or may not be there in 2026. We're working with about $8,800 per month. Ms. Stewart is asking that he pay $7,800 per month. That's not a possibility. If he were to pay $7,800 a month, he would have less than $1,000 a month for himself, probably less, because again, we're working with fake numbers. We're working with numbers that we're hoping the parties will earn by the end of this year and profit of that business. So the only way that I think this could work, and this is actually a pretty big risk to Mr. Stewart, because again, there's no money in the business bank account. He may get payments, he may get gigs, and he may have the money, he may not. If we take his net income from his teaching job and we estimate $5,000 a month from the business profit, and we get $8,800 a month, we split that in half. And Ms. Stewart, on a temporary basis, gets $4,400 a month. Mr. Stewart has $4,400 a month. As part of her $4,400 a month, he would pay the mortgage of $2,200 a month, and then he'd give her an additional $2,200 a month. That, again, he may have to borrow money to make that a reality if the business income isn't there, but that's really the best that we can do at this point to try to put a Band-Aid on this situation. And the only thing I can also say about the business is if there is any additional profit, that just gets held, reserve it. Hopefully we can get into mediation sooner rather than later to determine what's going to happen with the business, what's going to happen with the additional profit. But on a temporary basis, $4,400 to her, $4,400 to him is maximum, if not more, than what this man can do. There's no money there. So he is creating in his mind a theoretical solution that he will do his very best to maintain. What we're asking in total, Your Honor, is joint physical, joint legal custody, 2-2-5 schedule, or a week on, week off schedule, whatever the court's inclined to do. Award Ms. Stewart $4,400 a month in temporary support, but $2,200 of that gets paid to the mortgage. So then she'd get $2,200 in additional support. If she's making money, she can keep that money. We will preserve any additional profit in the business, provide an accounting every month, hopefully get this into a speedy mediation. We need her to relinquish her business credit card that she's been using. She just charged another $5,000 in attorney fees on that credit card just 3 or 4 days ago. So she's spent what we believe to be $15,000 to $20,000 in attorney fees since this case started. We got to stop the bleeding. We got to stop the joint credit card spending. She'll have to get her own credit card. She's got to relinquish that card. And in addition to that, in terms of parenting time, Mr. Stewart asked for spring break this year. He didn't provide facts to support that request. He's just requesting spring break this year. She has spring break next year. Just a simple request. And then I do want to make sure that the parties are going to file a joint tax return this year. And if the court is going to order that he give her the $6,200 that he transferred for taxes, she's just going to have a further tax liability when they file their taxes, Your Honor. Thank you.
Thank you, Mr. Van Hubel.
And a fine good morning. I think there are some points of agreement, Your Honor, that I think are coming through here. I think the easiest probably is they both have homes, so exclusive possession really doesn't appear to be an issue here from what I'm able to discern in this case for my client to have exclusive possession of the marital home. Second point, which is a change in position with defendant, and I'm okay with it, is to provide my client with $4,400 a month of support, child support. I'm perfectly fine with that. And I think my client would be too. The third piece, and this is the significant piece here, is the parenting time in this case. Quickly, my client my client's been a full-time homemaker for 14 plus years. She has homeschooled the children through the pandemic. Children are now enrolled in school, and but she does all the house cleaning, the cooking, transporting kids, medical appointments are basically, I would be safe to say 90% of my client doing all that. Pretty much everything on the home front, with the exception of homework, which um, my client tells me the defendant really loves. Well, probably the profession there. He really loves the homework piece, but other than that, it's been my client pretty much directing things on the home front. The concerning issue is the diabetes treatment, and that came through some time ago when Laura had her diagnosis of diabetes, and it's a serious thing. And there was treatment given by Pine Rest, and that's a good thing. But she was sent overnight with dad, and the child has an alcohol monitor, or alcohol, what am I saying? A diabetes monitor, that an app that shares where things are at in terms of her levels. And the app alerts you when the child goes too low. And so she had been overnight with her dad, so she called at 11. Dad didn't respond because she noticed the level was critically low. She kept texting and calling. Dad did not respond. The level was low. Finally, she started getting desperate. Dad sends her, doesn't respond at all that evening. The next morning, he tells her, "You got to go get your head examined. You need psychiatric help because you keep going on and on about these things." Well, diabetes is not something we go on and on, something we do something about. And we inform the other parent, hey, either the app's malfunctioning, or, I've taken care of this, something. She's kind of, almost in a panic because the levels are so low. And so in a critical realm, and telling her that she's, needs psychiatric help because she's concerned about her child's welfare. She's been the primary person monitoring her daughter's diabetes level. And that's serious, but dad, and this is a little snapshot, I think it's insightful. So they had diabetes awareness at school. Dad takes the victory lap, buys matching t-shirts at school. They got father and daughter come with their diabetes t-shirts. But at home, he's a different guy. That different guy is not the teaching guy, but he's the I let my spouse do all the work around the house guy. So my client's been running the household, seeing to everybody's every need contrary to claim, and letting my client do the work. And that's what they did. But now they're separating. But my client's still has been the primary caregiver in this situation, running everybody to everything and doing it all, frankly. Dad, and you can hear I'm going to talk just briefly about the business. I think we've settled the child support, so I'm not going to go into numbers now. He has income of 74,659 from his teaching job, but he is additionally working this business, which consists of consulting, speaking engagements. He gets book royalties both from his own things, but also from others who market their books on his platform. He sells products. He has other products. He has Etsy that he's doing product on. This is a fairly large enterprise. Why do I bring up what's going on with the enterprise? Dad is a busy guy, and he keeps a very busy schedule. And that's why my client was there taking care of the children and doing all the backstop work. She should get credit for that. The other problem that we're experiencing here is gaslighting. Dad's telling kids you have to pick sides. Don't tell mom what we're working on with homework. Keep her out of the loop. And he does not support her when their daughter called her an effing retard the other day. Dad said, well, you just he doesn't support. He didn't support at all. He basically just left her out to hang on that. We're not, what we're asking for is that he do the alternating weekends and a midweek. His schedule is a busy one. All of a sudden, as of lately, he's taken to picking up the kids from school. Now I'm going to be the cook. Now I'm going to be the game fun person. And there's been some voluntary reductions of income. But again, we agree on support, so I'm not going down that path. But he's all of a sudden trying to be, everything he was not and letting my client do all that work. In fact, often my client would ask him to do something. He would say, well, I don't feel like doing that. You'll have to take care of that. Um, this is the situation my client finds herself in. Just by way of information, he had an affair 2 years ago. He was out of the house for 7 months. He's come back, and it's been a lot of anger and victim mentality with him and in front of the kids. That's got to stop. The kids shouldn't be involved in any of these things, and there should be mutual support for both the parents. That's why we're asking for the schedule, because he's not co-parenting right now, and that's a severe problem. And it's impacting the children. You can hear it from some of what's been said today. So we're asking that this schedule be maintained. My client's been in opposition to the spring break time because she's just not certain he's going to follow through, do the diabetes monitoring adequately, and not use this as a gaslighting trip in addition. So there's our concerns, but there's what's going on in this situation, Your Honor. And the final thought is the mutual restraining order was put forth by the defendants here on an ex parte basis. We did not object. We signed it, and here we have a transfer a transfer and a failure to share information and trying to hold things and control things separately. We find that is a violation of the MRO, Your Honor. There's just no other way around it. So with that, I'm going to close. Thank you. I think like I said, we accept the $4,400 a month. We accept the parenting time. We accept the, exclusive possession. The parenting time is really the key issue here, Your Honor. Thank you.
All right, thank you. Ms. Oster, briefly.
Yes, thank you. First of all, the ex parte order was secured by plaintiff, who is Miss Stewart. I think there was a misstatement there. They said that we secured the ex parte order. We didn't file this case. As far as I'm pretty sure I'm the defendant, but
If we filed it, whatever, I'm sorry, I might have misspoke.
they got this ex parte order.
But still violated.
I'd like to ask my client if the court would allow. There was a very, very serious claim just made by Miss Stewart regarding, honestly, verbally abusive statements that Miss Stewart made to their daughter in regards to diabetes that I believe is completely untrue. So if the court would just let me ask him briefly, there was a claim that your daughter was with you, Mr. Stewart, and her monitor went very low, and you told her you need to have your head examined over her diabetes monitor. Can you, by chance, just briefly respond to that? Because that's a pretty serious an explosive statement that was just made.
This was when Crystal took a trip to the Upper Peninsula Bible Camp in late July, where she was gone for roughly a week. This was a night while she was away. I was monitoring Laura's diabetes. We have the glucose in range, blood range information from that week, and it was exemplary 92%. And Crystal was trying to contact me about low blood sugar. I was monitoring the situation. I did not see her text messages. The following day, I did not say that she needed to have her head examined, but I encouraged Crystal to let me monitor Laura's condition, which we have evidence to suggest was done very well that week.
Okay, thank you. That's all I wanted, Your Honor.
All right, thank you. I'm very happy to hear agreement on a couple of things, as indicated by Mr. Van Heuvel. So I'm going to limit myself to the remaining issue, which is physical custody parenting time. I do believe, based on what I've heard, that on a temporary basis, a 225 schedule would be appropriate. So I will grant the parties temporary joint physical custody and joint legal custody. I'll refer the matter to the front of the court for an investigation regarding custody and parenting time. I will indicate that both parties are to immediately respond to the other party regarding concerns about the children. Check your phone before you go to bed, if nothing else. Because when you have a child with particularly juvenile diabetes, that's really scary, and I can understand panic in that situation. It's really important that neither of you talk negatively to the children about the other parent. They internalize all of that. They feel they're half of each of you. And so if you are downgrading or denigrating the other parent in any way, shape, or form, they're going to internalize that and feel like there's something wrong with them as well. So I really beg you not to do that. Divorce is hard for kids, but it's even harder when they're really literally put in the middle of the case. Your job as parents is to protect them and insulate them as much as possible from all of this. It's between the two of you. It does not involve them. That Ms. Stewart turn over the her business credit card. That money that was set aside for taxes needs to be split. Of course, with the understanding that is some of that's going to have to be used for taxes, but it was a violation of the mutual restraining order. I will indicate that spring break will start with mother this year on a temporary basis. And that Mr. Stewart provide a monthly business accounting through the attorneys regarding what's happening with any of his businesses and his income. Is there anything further that I've missed?
The only thing, Your Honor, is filing jointly they're going to file
Oh,
their
yes.
taxes. And I don't want someone to just jump and file,
Right,
especially if they're
yes,
splitting that money.
yes,
Joint
yes.
filing? Okay,
Yeah,
and joint split
filing
of any,
tax.
joint split of any refund or,
Positive or negative,
perfect.
split it. Yeah,
So can I clarify, you would like that 6,200 transferred immediately, half and half?
half,
Yes.
half.
Because that was set aside to meet 2025 tax
Yep,
obligation.
but you're going to
Right.
have to split the tax payment. So we're going to file jointly for
Okay.
2025. So if she's taking that, it would
Understood.
be to her benefit to hold that for taxes.
Thank you.
And what would be the move out date, Your Honor?
Could he have a
Ms.
week?
Oster,
Could he have a week?
7 days is very reasonable.
I have no issue with that, Your Honor.
All right,
And then-
anything else?
Yeah, just
Start.
lastly, who wants to have the Monday and Tuesday? Who wants the Wednesday and Thursday? So that there's just no confusion when this does start.
Do you want Wednesday or Thursday or Monday or Tuesday? Monday, Tuesday for my client, Your Honor.
Okay, so then we'll say Wednesday, Thursday for Mr. Stewart, and then perhaps if he's going to be out in 7 days, can that be his first weekend? Wednesday, Thursday, Friday, Saturday, Sunday?
That makes sense.
Perfect. Thank you.
Thank you. And then the effective date of the start of support here. That's the last little piece.
I'd say when he moves out.
Right, yes, when he moves out. So
When he
that
moves
whatever
out.
that date, yeah, that first day.
And is he paying the mortgage or is she paying the mortgage out of the 4,400?
What would
This
you
one.
prefer, Mr. Van den Heuvel?
Who is paying now?
I mean, it was getting
Auto
deducted
deducted from
and-
the joint account?
Mhm.
We'll just continue from the joint account, Your Honor. It's auto deduction, so
Okay,
that works.
okay.
So he'll
Deposit,
Hey.
we can deposit straight to the joint account.
So the court lands on a clear temporary framework: joint legal and physical custody, a 225 parenting schedule, and strict expectations for communication, especially with a child managing juvenile diabetes. Financially, the judge flags the mutual restraining order issue, orders the business credit card turned over, requires monthly business accounting, and splits the money set aside for taxes while still pushing for joint filing clarity. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
So then she'll keep using the joint account. He will use a different account.